Okay, today we filed a notice of appeal as a result of People v. Hansen, which came down from the Illinois Supreme Court on June 24th and solidified for all time the concept of forfeiture by wrongdoing, the common law forfeiture by wrongdoing, which we've talked about over the last couple of years. It's clearly a change in Illinois law and a clear statement by the Supreme Court in a unanimous decision in a death penalty case where the review is given the highest level of scrutiny. And the court announced that the common law doctrine, which does not require a finding of reliability as to the statement, is now the law, clearly the law in Illinois. Judge White has issued a ruling under seal, which obviously I can't discuss. When Hansen came down, we filed another motion. Based on the ruling in that motion, that triggered the appeal that we filed today. And we used due diligence in proceeding, but the time limits came right at the end. Had Hansen come down a couple months ago, it would have been a lot easier, but it didn't. We were as ready for trial as we were for that 5-week hearing that you all covered. But in a criminal case, I only get one trial. There's a concept called double jeopardy. And I'm obligated as the state's attorney of Will County to make sure that when I go into court, I have all the evidence that I can possibly garner to make sure that I have a successful verdict on behalf of the people of the state of Illinois. And it is on that basis that we made the decision, and we did this after much consultation in the office and with the state's attorney appellate prosecutor's office. And I also talked to Joe Burkett, whose office handled this case on appeal. This arose out of a 2007 case that was tried in DuPage County, and the facts are very similar to the facts we have in this case. And the court held, I thought this was a very telling description by the court. They said, look, you do forfeit your confrontation rights to the individual that has been deterred from court, and you forfeit that by your wrongdoing. However, you still have the right to confront the third-party witness and test the reliability of both that witness and the statement that they're relating. But it's an equitable doctrine, and it's a forfeiture of your right to cross-examine because of your wrongdoing. And for the first time in Illinois, that's clear. And so all the editorials that have been written about the statute that was passed, those pretty much are put to rest. They no longer apply in Illinois anymore. And our statute clearly said that we were preserving the concepts of the common law forfeiture by wrongdoing. The legislature specifically said that the statute that was enacted did not in any way impair the integrity of that concept. So that concept fully applies here in Will County as we stand here today.
Jim, are you worried about the strength of your case? Are you worried about the strength of your case? Is that the reason you went ahead and filed this appeal?
No, I filed this appeal because there is evidence that I believe that we should have available to us, and we're going to ask the appellate court to consider that under the Hansen case. As I told you, we went through a 5-week hearing prior to this trial. We've been preparing for trial. We're ready for trial. I have an excellent team. They've worked tirelessly, and we're ready. But at the same time, I've got an obligation to look and see if there's anything additional that would be extremely relevant, and we made that decision. What else would they say? They think everything's a big joke. Everything's funny. This is not a funny case. This is about the murder of a mother of two, and it's a very solemn matter. Everything's flippancy and nonsense. Everything's misdirection. Take your eye off the ball. Don't look at what really happened in this case. That's not what we do. We religiously avoid comment on this case, and I'm going to continue to do so. But these kind of comments about chickening out, anybody that knows me, I've been in this business for over 30 years. There's not a single person that would call me a chicken, and it's just not going to be done. I've taken some of the most difficult stands in criminal cases of any prosecutor in the state of Illinois. Look at my record. I've made decisions that have made law enforcement extremely upset with me. That's against my own self-interest. I did it without hesitation. Most recently, the Fox case might come to mind. And then what my decision was borne out. These are tough decisions, and this is a tough decision here. I made it because it's in the best interest of the people of the state of Illinois and the citizens of Will County.
Jim, could you have won this case without the hearsay evidence you're
trying to get back in?
Chuck, you know I can't comment on that. Obviously, we were confident in our case. That's why we brought it.
What's your time frame, Mr. Glasgow? How long does this process take? How long does it take?
Again, this is a process that is beyond my control as far as the timing. It could be. I really don't know.
Do you have to make oral arguments? Is that?
Yes.
Oh.
Yes, there'd be briefing and briefing schedule, and then it would be set for oral arguments.
So are we months out?
yes.
Jim, can you explain that Drew Peterson maybe let out of jail? Did they make it deny bond?
The statute says that during the pendency of an appeal, that an individual cannot be held in custody or held to bail unless there are compelling reasons to do so. And we will be applying to the court for a hearing on that issue. To decide that matter, I would call your attention to the fact that the Appellate Court of Illinois upheld his $20 million bond.
Jim, can you explain?
I'm sorry.
The application for release, or you make the application to keep him in?
No, the statute says that he cannot be held. So the court will have to make that determination in an expeditious manner.
When might that happen?
Probably tomorrow morning.
Okay, can you explain what, in layperson's terms, the specifics about forfeiture of wrongdoing in regards to Hansen? Can you explain what exactly it was in that case?
In this particular case, it involved the defendant. The state proved at a hearing that the defendant murdered his sister. He had said to her, "If you tell our parents that I'm stealing from you, I will kill you." She then told that to her sister, and the state moved to admit that statement through the sister. And they had a hearing. At that hearing, they proved by a preponderance of the evidence that he killed his sister, and he did so with the intent to silence her so that she could not testify to that statement. Under the doctrine of forfeiture by wrongdoing, once that's done, you prove that intent to silence, you forfeit your right to cross-examine the deceased person. There is not a requirement of reliability because it's an equitable forfeiture of your right to confront them, and the sister was allowed to testify. They also pointed out, and courts don't always go this far, but they pointed out, I think very succinctly, that you don't forfeit all your right to cross-examination. The sister was vigorously cross-examined. They can test her credibility, they can test the circumstances, her memory, the contents of the statement through that third party.
So can we deduct that this has to do with Stacey Peterson telling someone else about
I can't comment on the evidence. I can only comment on Hansen, and that our appeal is based on Hansen. But I can't comment on the facts in this case.
Okay, that's the last question, so thank you very much. We appreciate